Okay, greetings everyone. This is administrative law, and this lecture is going to be on procedural fairness, section 4 of Paja. We're going to start off with a legislative analysis of Paja section 4. We're not going to be reading, Paja, the legislation of Paja in terms of section 4. This can be read individually. However, we are going to look at the explanatory notes on Paja section 4, which is this. And we're going to touch on this explanatory note, which deals with Paja section 4. And the first thing that we must note is that section 4 is triggered when the administrative action has a general impact. That means that the administrative action must apply to members of the public equally and impersonally, although it may affect some individual members of the public more than others. Examples of this are through regulation, prohibiting the consumption of alcohol on Sundays, right? So, Paja Section 4 deals with procedural fairness as it regards to administrative actions that have a general impact. That means that they impact the public in general and do not target some members of the public, although some members of the public may experience the effect of the administrative action more adversely than others. Its intended purpose is that it has a general impact, all right? It has also a significant public effect, right? The significance and or materiality requirements will depend on the circumstances of each case and should be judged cumulatively rather than in relation to a particular section of the public. Example, regulation requiring background of number plates to be red instead of yellow would not satisfy the material test. That means it would not have a significant public effect, right? Asking the public to change the color of the number plates to red instead of yellow is not going to affect the public materially. So it must have then a significant public effect if Section 4 of Paja is going to be triggered, right? The next one is that the rights of the public are an issue or must be an issue. That means the action impacts on the rights of members of the public rather than individual rights or the rights of individuals, as we've noted that in regards to the rights of the individuals, then Paja Section 3 would apply, right? Section 3 will apply. This is in regards to the public, and so Section 4 applies. Okay. We're then going to look at the regulations on fair procedures. You can read about this alone, but we're going to touch on, in regards to the regulations on fair procedures, we're going to look at the explanatory note on these procedures. In particular, firstly, we're going to look at the public inquiry section, section 4.2. And so there are 3 stages to a public inquiry, which includes a notice of the inquiry in the Government Gazette and information on who will preside over the inquiry, right? You then have the hearing stage, which operates like a trial with rules of evidence, and the swearing in of witnesses is required during the hearing stage of the public inquiry, right? When you read on Paja section 4, you will find that the administrator, in terms of giving effect to procedural fairness as it relates to administrative actions that have a public effect, will then decide to engage in either what is known as a public inquiry or a notice and comment procedure or any other procedure that is provided for in specific legislation or anything that gives effect to Paja Section 3, or they may depart from that requirement, right? You can go ahead and read Paja Section 4 um, individually, right? For the sake of time, we will not be going through it. However, Paja Section 4 is relatively easy to understand, right? Section 4A engages the matter of the administrator may depart from the requirements of Paja Section 4.1, right? Section 4.3 talks about the notice and comment procedure. Section 2 about the public inquiry, and Section 4.1 is whereupon the decision is made. All right. Okay, let's go back now to the explanatory note on the regulations in terms of these procedures that are provided for in Paja Section 4, right? We then come back now to the public inquiry, where the third stage is the reporting stage. So after the preparatory stage, that means giving notice of the inquiry, etc. The hearing stage, and that is conducting the inquiry. You then have the third stage, which is the reporting stage, where a report at the completion of the public inquiry must be drafted timeously and include reasons for the decision or decisions taken. All right. A public inquiry, as you may understand, is where administrators will invite members of the public, perhaps maybe at a hall. They will again get to discuss and put in their proposals, their evidence, and debate the issues or the decision that's being required to be taken. And the administrators will then take those considerations, those inputs, those representations into consideration when they make their final decisions. And so this is basically then explaining the three stages of the public inquiry. You then have the four basic steps of the public inquiry procedure. Now, before the inquiry, the administrator must decide whether to conduct the inquiry themselves or to appoint another person or panel of people to conduct it for them or on behalf of them. This is provided for in Paja Section 4.2, right? The administrator must give notice of the inquiry, which must include details and information about the matter and issues being investigated at or during the public inquiry. They must then give notice of the public inquiry. The first part is to decide who's going to preside over that inquiry, whether it will be the administrator themselves or they're going to appoint someone else in their place to conduct it for them. The second step then would be to give notice to the public of the public inquiry so that the public may participate. Once that notice is given, a public hearing must be held, right? A public hearing must be held where then the matters that were set down for discussion are then discussed. Okay, and then after the public inquiry is completed, the administrator must compile a written report and publish a summary of that report for the public's viewership, right? We then look at the explanatory note on the notice and comment procedure, which is found in section 3. We note that there are four basic requirements for a notice and comment procedure. A notice and comment procedure, in particular in regards to regulations, is where a particular proposed decision is published for comment, right? Where the members of the public can provide comment on what do they think about the proposed decision, all right? Now, the four basic requirements for a notice and comment procedure is that the public must be given enough information about the proposed administrative action to allow them to make meaningful representations. That is very important, is that the public must be given enough information to allow them to make meaningful representations, right? They cannot be given what is known as scant information or insufficient information. The information must place them in a position to be able to then provide meaningful representations. That is, a notice must be given which sets out enough information on the proposed action, All right. The administrator must then call for comments on the proposed administrative action and must allow enough time for those comments to be made. They must not only just call for comments on the proposed administrative action, for those representations to be meaningful, they must also allow for enough time for those comments to be made. The administrator then must consider the comments received, right? They must consider them. They do not have to adopt the comments, right? But they must consider them, right? There's a difference there. One is that they must consider them in their decision-making process. However, they are not obligated to adopt the comments, right? The administrator then must decide whether or not to take the proposed administrative action with or without changes. So again, noting from the above, right, they must consider the comments made. However, they have a discretion on whether or not to amend the proposed decision, which would include amendments as informed by those comments. However, they are not obligated to adopt them, right? They may still proceed with the same administrative action. However, they must consider it and provide reasons as to why they did not use it, but they are not obligated, right, to adopt those comments. Okay, we then come now to the case law, right? And so the first aspect in terms of procedural fairness, section 4, we deal with administrative actions in which Paja section 4 would apply, and we look at administrative actions, case summaries, right? The first case is, let me change the color. It's not, okay. Okay, so the first case is Minister of Home Affairs versus Essenberg and Associates. So we look at the facts of the case. Essenberg and Associates launched an urgent application in the Cape High Court to declare immigration regulations, right, that were made on the 21st of February unlawful and invalid. The High Court granted that order, finding the regulations to be invalid, right? Finding the regulations to be invalid, right? Because the minister had failed to follow the public consultative process required by the Immigration Act, right? Now, the primary issue in this case was whether the extensive public consultative process required by Section 7 of the Act, which involves the public and the Immigration Advisory Board, applied to regulations made under Section 52, which Section 52 allows the minister to make regulations before the Immigration Advisory Board is fully constituted, right? So in other words, does Section 7 of the Immigration Act, which mandates a public procedure that involves the public and the advisory board, does it apply to regulations that are made under Section 52? Let's see what the court says in regards to these issues. The court's findings were that Section 7 of the Act contemplates a scenario where the board is already constituted, right? Section 52, however, was specifically designed for the transitional period before the board is operational. Therefore, the minister was not required to follow the extensive notice and consultation procedures of Section 7 when acting under Section 52. Why? Because Section 52 was a transitional procedure, or it was a section that was designed as a transitional period where the board was not constituted, right? Before the board was constituted. The court then looked at whether then Paja applies to these regulations. The court considered whether Paja applied, right? Whether Paja applied to the making of these regulations on immigration, right? And it noted that Paja's definition of decision does not explicitly refer to the making of regulations, leaving it open to doubt whether this qualifies as administrative action. So the court here is basically saying that it is in doubt whether the making of regulations can be considered as administrative action. The court held that even if Paja did apply, right, the minister was justified in departing from the standard notice and comment procedures under Section 4.4 of Paja. So the court is stating, even if Paja applied, not that Paja applied. Remember, the court was in doubt whether regulations may be considered as administrative actions, but nonetheless engaged the exercise, stating that even if Paja did apply, the minister was justified in departing from the standard notice and common procedures under Section 4 of Paja. Why? The court held that the Immigration Act was set to come into force on the 12th of March. Without these regulations, right, the act could not be implemented. In other words, if the act coming into operation of 12th March, the board, right, the advisory board that was set up to make regulations that also include procedures for the public had not yet been established, there would be no regulations then in regards to implementing the act. And so Section 52 of the act then provided for these transitional arrangements, right? In other words, the regulations made by the minister in the time being, right? The act could not have been implemented. The court continues then that given this urgency, it was reasonable and justifiable for the minister to skip on the notice and comment procedure provisions to ensure the effective administration of that law, which is the Immigration Act, right? So the court said that it's reasonable and justifiable. And remember, Section 4 then states that an administrator may depart from the requirements of Section 4.1 if it is reasonable and justifiable. The court here finding that even if Paja did apply, the minister would be justified in that the urgency, that means the need to provide for regulations in terms of the act was urgent, it was needed, and therefore it was reasonable and justifiable for the minister to then depart from the notice and comment procedures. That's the court stating that if Paja were to apply. However, the court decided the issue also in terms of the act, finding that Section 52 is for a different purpose, and Section 7 was for a different purpose, and that the provisions of Section 7 do not apply to the provisions of Section 52. Okay. Now, remember in the previous case on Essenberg, the court had held that it was in doubt whether regulations may be considered as administrative actions. We then get clarity, right? We then remember Essenberg is a 2003 case, Minister of Health and versus Nuclix is a 2006 case, both constitutional court cases. In this case then of Nuclix, the court then decided this issue of whether regulations may be considered administrative actions, and we'll see what the court has to say about that in a moment's time. Okay, let's look at the facts. In this case, right, regulations were made by the Minister of Health, acting on the recommendation of the pricing committee to establish a pricing system for the sale of medication. In essence, the minister wanted to ensure that certain medications were reasonably priced or were cheap so that people can afford it, right? in trying to give effect to the rights to healthcare, right? And so the validity of these regulations were challenged by New Clicks and others, which were pharmaceutical companies, right? Leading to conflicting decisions in the High Court and Supreme Court before it then now is before the Constitutional Court. The issues that the Concord had to decide then was whether Paja applies to the recommendations made by the pricing committee and the subsequent making of regulations by the minister, and whether the proceedings were rendered unlawful, unfair, or unlawful. Remember, these regulations now apply to the public, so Paja 4 gets involved. And so when they talk about unfairness here in terms of Section 4, and unlawful because not all members of the pricing committee were present, right, at every meeting or during oral representations. So there were two issues essentially. The first one is whether Paja applies, right, to regulations, and whether, if it so applied, whether Section 4 requirements of Paja were met. Okay. Now, let's look at how the court deals with the first issue, which is, does Paja apply to regulation making? The court concluded that the making of regulations the court concluded or held that the making of regulations in this case, while in every other case since, did constitute administrative action under Paja, and the court provided its reasoning for this. The first is that both the minister and the pricing committee are considered organs of state. The regulation of these prices adversely affected the rights of pharmacists and other pharmaceutical industry and others in the pharmaceutical industry by fixing the price at which medicines are sold. The court then looked at the definition of decision, and the court noted that although the making of regulations is not explicitly listed in the specific subparagraphs of the definition of decision in Paja, the court held that it fell under the general scope of a decision of an administrative nature, as it involved the implementation of legislation, right? The court also found that the implementation of legislation, including the making of regulations, remember, regulations are made in terms of legislation, or legislation, a particular legislation may mandate the making of regulations, such as in the previous case where the Immigration Act provided for the making of regulations in Section 7 and Section 52. In this case, the particular health legislation provided for or mandated the making of regulations, right? And so the court found that the implementation of legislation, including the making of regulation, was deliberately not excluded from the definition of administrative action in Paja. The court held to exclude the making of regulations would be inconsistent with the right to just administrative action, as it would in essence exclude all administrative actions. Why? Because all administrative actions involve the implementation of legislation, whereas other acts such as the executive acts would be the implementation of policies. If you remember the case of Masetla, the case of Sarfu, and various other cases, we find that the difference between administrative actions and executive or legislative actions or other actions involves that a difference in that administrative action involves the implementation of legislation, right? And so regulations, by their nature, are an implementation of legislation because they are mandated by legislation, right? And so the court found that they are by their nature administrative actions, even though, and found further rather that they were not deliberately excluded, all right? those were some of the reasonings of the court in deciding the issue that then regulation making are administrative actions that are subject to Paja, right? The court then went and looked at the second issue, which was whether the pricing committee's procedure was fair. The court held that the proceedings were not unfair or unlawful, despite some members being absent at certain stages. And it provided its reasoning below. It stated that, unlike adjudicative bodies, the pricing committee's role involved research and information gathering, which did not require every member to attend every meeting. The court then also held that in the absence of a prescribed quorum in the Medicines Act, remember, the Medicines Act then was the act that mandated the regulations or the making of regulations by the minister, which involved the pricing committee, right? This Medicines Act did not prescribe a particular quorum that certain members must be present, perhaps a 50+1, or that all members must be present, and that all members must be present at every meeting. So the court found that the Medicines Act did not prescribe such a quorum. It also looked at its role, that its role was not adjudicative, right? It was rather involving research and information gathering, and that the committee then, in the absence of this prescribed quorum, was entitled to determine its own methods of work. That means how it would go about doing its business of these meetings. The court then looked at the aspect of meaningful participation, and the court found that the process was highly public, including forums, stakeholder meetings, and opportunities for written and oral representations. The court found that stakeholders, that is the pharmacists, such as NuClix and others, had a fair opportunity to voice their objections, which actually led to material changes in the final regulations. So some of the stakeholders' recommendations on the pricings were taken into considerations. And in fact, the new prices or the prices that were adopted in the regulations were significantly reduced from higher prices to lower prices. Okay. And so the court found that actually there was meaningful participation. And that was one of the reasons why it found that the procedure that they adopted, whilst they did not attend every meeting, or all members did not attend every meeting, it was still a fair process. The court ruled that then the making of regulations constituted administrative action subject to Paja. However, it found that the specific procedures followed by the pricing committee and the minister met the requirements of procedural fairness, right? Okay, we go on now to the next case involving administrative actions. And what we find then from the first two cases then is that administrative actions include regulations or the making of regulations. Okay, we then go then to the third case, which is MEC, Department of Agriculture, Conservation and Environment, and another versus HTF developers, right? In this case, HTF developers planned to subdivide their property for residential sale, right? The head of Department of Agriculture, Conservation and Environment identified their property as virgin ground and determined that the clearing of it in order to subdivide it, right, without authorization would cause serious environmental damage, right? So the department issued a notice of intent to use Section 31A of the Environment Conservation Act to stop the development, right? HTF was given a 48 hours notice to provide reasons why the directive should not be issued. That directive in terms of Section 31A, that they should not develop the land, right? Despite HTF's legal challenges to the virgin ground classification, the head of department issued the directive ordering construction to stop. And so they took this matter to court, and the court had to decide the particular issue that the court had to decide was whether an exercise of power under Section 31A of the ECA, which was aimed at specific individuals, must follow the mandatory 30-day notice and common procedure required by Section 32 of the same Act, right? So Section 32 mandated a 30-day notice period, right? And so here was whether that procedure also applied to the procedure of Section 31A, which involved specific individuals, right? Section 32 was a procedure that involved the public or was aimed at the public, right? The court then, deciding this issue, found that there was a distinction between the directions. The court distinguished between the directions intended for the general public, which required gazetted notice under Section 32, and directions aimed at specific entities under Section 31, right? So gazetted notice under Section 32, which called for a notice and comment procedure, was intended for the public, the general public, whereas Section 31 was intended for specific individuals, right? The court found that it was inapplicable. So the court found that Section 32 was inapplicable. The court found that the 30-day notice and comment procedure of Section 32 is not required for Section 31A directions, as such a delay would defeat the purpose of responding promptly to environmental harm, in particular because it involved one individual's property and not the properties of the public in general, right? So the court found that it would be inappropriate, right? It would cause delay, especially because serious environmental harm was at threat, right? Because there were various kinds of animals there in that particular property. And so you can imagine then the need for the department to respond promptly. So the court held that while Section 31A is subject to procedural fairness under Section 3 of Paja, remember, it involves an individual, it allows for flexibility depending on the urgency of the situation, right? The court held that under Section 3(4) of Paja, an administrator can deviate from standard notice requirements if it is reasonable and justifiable, such as when serious harm is threatened, right? So the court found that the administrator, then the head of department, can deviate from those procedural fairness requirements if it's reasonable and justifiable. And so the court came then to its conclusion that in light of the threat of the serious and continuing environmental harm, the 48-hour notice period provided to HTF developers was adequate and met the procedural fairness standards of Paja, right? It met the procedural fairness standards of Paja. Okay, so that's how the court dealt with the issues in this case. We then look at the last case that involves procedural fairness, right, involving administrative action. And we look at the case of Esau and others versus Minister of Corporate Governance. The cases of 2021, right? So the facts of this case now. Following the declaration of national disaster due to the COVID-19 pandemic, the minister promulgated regulations to implement a lockdown, right? We all remember this, right? And on 29th of April 2020, level 4 regulations were introduced to lower the restriction levels. The applicants challenged these regulations, arguing that the public was only given a 2-day period to make representations, right? They called for a notice and comment procedure, and the public was only given 2 days to respond, which Esau and others claimed was procedurally unfair and irrational, right? So the court in this case had to determine the following issue. The court had to determine if the making of these regulations complied with the procedural fairness requirements of Section 4 of Paja, specifically regarding whether notice, whether the notice provided enough detail, and if the 2-day time frame was adequate, right? Was adequate for them to make meaningful representations through their comments, right? The court's finding was on the applicability of Paja. The court confirmed that Section 4 of Paja applies to the making of subordinate legislation. Another word for subordinate legislation is regulations, right? So they can be used interchangeably, but subordinate legislation simply means regulations because they are subordinate to the particular act that mandates them, right? And then the court continued that for any chosen procedure to be fair, the administrator must ensure, right, the public is given adequate notice and an adequate opportunity to be heard, right? So the court held that for any, very important, for any chosen procedure to be fair, remember, chosen procedure is within the allowed procedures. You can't just now choose any procedure. That's not what it means. It means within the allowed procedures in Paja or in the particular act, right? It must ensure that the administrator must ensure the public is given adequate notice of the proposed act and an opportunity to be heard, right? The court also found that the minister provided sufficient detail to allow the public to make meaningful representations on the content of level 4 regulations. This involves the lockdown regulations, right? The court found that the minister is required to assess the urgency of the matter and calibrate the procedure, including the time allowed for comments to the degree of the urgency. In other words, the court found that urgency is a consideration when the administrator decides the type of procedure, right, that they are going to embark on. And it's also a factor that's considered when deciding or determining whether a particular procedure adopted was fair. And so the minister was required then to assess the urgency of the matter and calibrate the procedure, including time allowed for comments, to that degree of urgency. And as the minister uh, contended for, was that the matter was urgent, right? It involved the regulations of level 4 lockdown, and the court found that the court, when viewed holistically within the context of an unprecedented national disaster and the need to quickly ameliorate economic and social hardship, that means lessen the impact of those economic and social hardship, the court ruled that the 2-day notice and comment period was reasonable and that the minister had applied her mind appropriately, right? The court then essentially is saying that the procedure adopted by the minister was fair, right? So on these issues, the court said Paja did apply and that the process was reasonable. It was fair, right? It was fair. So the fact that it was reasonable also meant that it was a fair procedure. The court then looked at procedural rationality, and the court held that even even if the regulation making was considered, not that it is, but even if it was considered an executive action rather than administrative action, it still had to meet the standard of procedural rationality. Remember, we discussed procedural rationality when we dealt with the topic of legality, which involved also rationality, which includes a procedural aspect. The court is saying that even if regulation making was considered an executive action rather than an administrative one, it still had to meet the standard of procedural rationality. And the court held, the minister could not rationally decide on regulation content without public input, right? In order for it to be rational, right, the regulations to be rational, they would have to consider public input, right? And that for the same reasons that they made the process fair, it also made the process rational if it were to be considered executive actions, right? And so the court essentially found no fault, finding that the regulations were fair, right? The regulations were procedurally fair under Paja. We now look at executive actions and whether procedural fairness applies. We look at the case, the famous case. Now, we've dealt with this case many a times, the case of Masetla versus the president, right, of the republic. The facts are that Mr. Masetla was appointed as the national head of intelligence, right? He was later suspended by the minister, right, for him having been found to have misled them on the Makazoma affair. And the president amended his term of office, which resulted in his early release, or what is known as his dismissal. And so the primary issue was whether the president's decision to amend Mr. Masetla's term of office was reviewable by the court, specifically to determine if the president's power to dismiss was subject to the requirements of procedural fairness in Paja. As Mr. Masetla argued, he was entitled to an opportunity to be heard before being dismissed. The court deciding these issues found that Section 2092 of the Constitution gives the president the power to appoint the head of the National Intelligence Agency, which implicitly includes the correlative power to dismiss or amend the term of office. That being the case, the court noted that Section 1 explicitly excludes the president's executive powers under Section 85(2)(e) of the Constitution from being classified as administrative action. Consequently, the president's decision constituted an executive action, making it exempt from administrative review under Paja. So, firstly, the power, right, is an executive power. That power is excluded, right, from being classified as administrative action. It's excluded from Paja review, right? And so the court then now looked at the requirement of procedural fairness and found that because the dismissal was an executive action rather than an administrative one, the court ruled or held that it would be inappropriate to constrain this presidential power with the requirements of procedural fairness, right? And the court held that although procedural fairness was not required in regards to executive actions, right? The court held that executive power is still subject to the principle of legality, which requires that the president must act lawfully and any decisions must be rationally related to the purpose for which the power was granted, failing which it would be rendered that the decision is arbitrary and contrary to the rule of law. All right, we've dealt with this case many a times, and we should know by now that executive actions simply are not subject to Paja. That means that procedural fairness is not a requirement, and that even that being the case, executive actions are still subject to review in terms of the principle of legality, which requires that the decision must be lawful and that it must be rational, right? The court concluded then that the dismissing of Mr. Masetla based on an irretrievable loss of trust is not inherently arbitrary or irrational, and that ultimately nothing suggested that the president acted arbitrary or without sufficient reason in the case, right? So the court found that the president claiming that the reason for his dismissal of Mr. Masetla was because of a lack of trust. Remember, it had been found by them that he had misled them on the Makozoma affair. That brought about this breakdown of trust, and because of that, he dismissed Mr. Masetla. The court found that that was rational. There was nothing arbitrary or irrational about that decision or what informed that decision. Okay, we now then look at legislative actions and procedural fairness. We look at the case of Doctors for Life versus the National Assembly, right? The, the case was brought directly to the Constitutional Court by Doctors for Life, right? The organization argued that the NCOP failed to invite written submissions and conduct public hearings before passing certain health bills. The central question, right, concerned the nature and scope of the legislative organ's constitutional obligation to facilitate public involvement in the lawmaking process and the consequences of failing to meet that obligation, right? The court found that Section 72(1)(a) and 118(1)(a) of the Constitution impose a clear duty on the NCOP and provincial legislatures to facilitate public involvement in their legislative processes. So there's a clear duty on them to facilitate in terms of the Constitution. There's a clear duty imposed upon them to facilitate public involvement in their legislative process. The court held that this essentially means or entails them taking active steps to ensure the public can participate in the legislative making process. The court held further that the constitutional framework seeks to balance representative and participatory democracy, and to achieve this, Parliament and provincial legislatures are granted a significant measure of discretion to determine how best to fulfill their duty to facilitate public involvement. They have this duty to facilitate public participation or public involvement. However, how they go about doing it is at their discretion, right? The court then found that despite this leeway, this discretion in determining how to best facilitate public involvement, they must nonetheless still act reasonably in carrying out this duty, right? They are subjected to this standard of reasonableness in terms of how they go about conducting or providing for meaningful participation in the legislative process, right? The court outlined several factors then to determine if the legislature acted reasonably, and that includes the nature, importance, and urgency of the legislation, the intensity of the legislation's impact on the public, practical considerations like time and expense, though the saving of time and money does not justify inadequate public involvement, and D, what Parliament itself deemed to be appropriate public involvement under the circumstances. So when the court then is now determining whether Parliament had acted reasonably in carrying out its duty to facilitate public involvement or public participation in the legislative process, it will consider what Parliament has decided to do against these particular factors that it set out here, right? And if it finds that it was unreasonable, they will set aside that decision, or if they find it reasonable, they will let that decision stand, right? And so the court also, in terms of the duty to carry out public involvement, the court established that facilitating public involvement requires at least two things. That is, providing meaningful So the court says that this duty to carry out public involvement requires at least two things. Remember, don't get confused. This is determining whether it's reasonable. This is then determining what the duty entails, right? It entails providing meaningful opportunities for public participation in the lawmaking process, meaningful opportunities of public participation, and taking measures to ensure that people actually have the ability to take advantage of those opportunities. So let me give you an example. If Parliament decides in its legislative making process that it's going to be holding a public inquiry, perhaps in regards to a particular legislation on perhaps, let's say, the use of AI or responsible AI, and then decides that it's going to carry out its public inquiry process at 2 a.m. in the morning on a Sunday night or 2 a.m. in the morning on a Monday morning to 5 a.m. in the morning, right? That would not be right, creating a situation where people can take advantage of the opportunity to meaningfully participate, right? Because people are sleeping at 2 a.m. to 5 a.m. on a Monday morning. They're sleeping because they have to wake up and get to work, right? So you begin to see that. So they must then, in other words, it's not only that they must provide meaningful opportunities for public participation, they must also ensure that people actually have the ability to take advantage of those opportunities. And in the example I provided, we found that if Parliament would then say that, listen, the public inquiry would be held at 2 a.m. on a Monday morning, you're not putting the public in a position where they can take advantage of that opportunity, right? And then the court held in regards to its ability to then get involved in this process, right, in determining whether legislation or parliament's activities, right, whether they are reasonable. The court held that while courts must respect parliamentary institutional autonomy, another way of saying must respect the separation of powers, they must also protect the public's right to participate. Remember, the court provides a duty on Parliament and provides for this right to participate. The court is saying that even though we must respect the separations of power, we must also protect the public's right to participate in terms of the right to participatory democracy. The court determined that this balance is best struck when evaluating whether Parliament's actions to facilitate public participation were reasonable, again, against the standard of reasonableness, right, in each specific case. So Parliament, the court is saying that we will get involved in this process if we find that it's unreasonable, right? And that's the basis upon which we're going to get involved, right? So let's look at the next legislative case in terms of procedural fairness. We look at, right, the case of Matatiela, right, versus the president, right? The core issues was whether the transfer of the Matatiela local municipality from KwaZulu-Natal into the Eastern Cape province, right? So it involved that dispute that the local municipality of Matatiela was transferred from the province of KwaZulu-Natal to the province of the Eastern Cape. The legal issue before the court was whether parts of the 12th Amendment concerning KwaZulu-Natal and Eastern Cape were adopted in accordance with the Constitution, the consequences of any non-compliance with the constitutional procedures, and the overall constitutional validity of the Repeal Act, right? The court's finding on this was that in terms of section 74.8, the court held that whenever a proposed constitutional amendment alters provincial boundaries, section 74A of the Constitution is engaged, and this required that the legislatures of both KwaZulu-Natal and the Eastern Cape Province to approve the parts of the amendment specifically concerning them. All right, that's what section 74.8 required, right? The duty to facilitate public participation. The court determined that the process of approving a provincial boundary alteration is a provincial legislature process under section 118(1)(a). Consequently, provincial legislatures are required to facilitate public involvement, right, in terms of section 118(a). Right? The provincial legislatures are required to facilitate public involvement, which may include providing opportunities for written or oral representations. And again, when it comes to the legislature, the court imposes the standard of reasonableness. The court held that the nature and degree of required public participation depend on factors such as the legislature's importance, urgency, and the intensity of its impact on the public, the court noted that when a specific identifiable group is intensely affected, the legislature must be particularly astute in ensuring they have a reasonable opportunity to participate. This is very important. In other words, what the court is saying is that a particular piece of legislation, such as the amendment that affected the change of Matatiela local municipality from KZN to Eastern Cape, meaning that the service delivery and the budget of that municipality, the cultural impact of separating this community from KZN to Eastern Cape, etc. It's really going to affect these particular communities. It's going to have an intense impact on specifically communities in this municipality. It's not going to affect people in Cape Town. You know, it's not going to affect people in Joburg. It's going to intensely affect people of the Matatiela community. And because it's going to specifically, they're an identifiable group, it's that community, they're going to be affected intensely by this change because it's going to affect service delivery, budgets, cultural and community social relationships. The parliament or the legislatures must ensure that these groups that are identified and are going to be intensely affected by it must have an opportunity to participate. They don't have to then give participation for everyone, all right? But it's important that these people are considered because it's going to affect them more intensely, right? So that's very important, right? So, okay, the court's decision, right? The court found that the Eastern Cape Provincial Legislature was found to have complied with its duty, right, to facilitate public involvement because it held public areas, it held public hearings in the affected areas, right? It held public hearings in the affected areas, right? However, KwaZulu-Natal failed, right? KwaZulu-Natal legislature was found to have acted unreasonably because it failed to hold public hearings or invite written representations, right? This failure violated Section 74(8) and Section 118(1)(a) of the Constitution. Now, because of this procedural failure by the KwaZulu-Natal legislature, part of the 12th Amendment that transferred the Matatiela municipal area to the Eastern Cape was declared inconsistent with the Constitution and therefore invalid. Okay, so you look now, the court in these legislative procedures looking at the reasonableness found that it was unreasonable, right? That this constituted a procedural failure. Remember that the court held that Parliament must also comply with the manner and form procedures or requirements, right? Which includes these procedural fairness mechanisms, right? And that failure then rendered the 12th Amendment, right? And also the Repeal Act, right? Inconsistent with the Constitution and invalid. Okay. We now look at foreign law case summaries in regards to this matter of procedural fairness as it involves or as it pertains to the public. We look at two United States of America cases. The first case being United States versus Nova Scotia Food Products Corp. All right. In this case, Nova Scotia Food Products Corp, what is known as Nova Scotia, and its directors in the business are in the business of processing hot smoked whitefish, right? The FDA, which is the Federal Drug Administration Agency, right, issued time, temperature, and salinity regulations requiring fish to be heated to specific high temperatures, example 180 Fahrenheit for 30 minutes, to eliminate the risk of botulism, right? This toxin that's found in fish, Clostridium botulinum toxin, right? Botulism, basically. Nova Scotia did not dispute that they failed to meet these requirements, but challenged the validity of the regulation itself, right? They argued that the high heat would completely destroy white fish, making the process commercially unfeasible. In other words, if they were to comply with these regulations, the commercial viability of selling white fish, hot smoked white fish, would be unviable or not be feasible, right? And so the issue that the court had to decide was whether the FDA had the power to regulate food processing to destroy naturally occurring microorganisms, right? One of the contentions in this case was that the FDA was limited to inspecting whether there were rats or rodents, right, in the plants. But here, the legal question then is, are they also allowed to regulate naturally occurring microorganisms, right? And number two, the second issue was, did the FDA's failure to disclose the scientific data it relied on during the comment period render the regulation invalid? There were data that the FDA used, however, it did not make this data available during the comment procedure so that interested parties could object to them or challenge them. It did not make that data available. And so the question was whether that failure to disclose the data, right, that informed the regulations, whether the failure to disclose that data rendered the regulations invalid. And number three, the third issue was, did the agency's concise general statement on the regulations adequately address material comments regarding commercial feasibility and alternative methods, right, to process hot smoked fish? Remember, in this case, Nova Scotia had already been using a different process that it considered, all right, to adequately remove or destroy this botulism toxin. And must be noted that on a further reading of this case, very few cases of botulism were recorded. I think perhaps 5 or 4 in 2 decades. So Nova Scotia had its own process that it considered appropriate and adequate, right? So the court's findings then on the issues that were brought about by this case, the court held that the court upheld the FDA's statutory authority, ruling that public health legislation should be read broadly to protect the public. And so what the court is saying here is that even though the power is not explicitly stated, right, the FDA is mandated to protect the public as it regards food, right? And so it does have that power, right? And so it should be read broadly to protect the public. In regards to procedural invalidity, the court declared the regulations procedurally invalid as it applied to hot smoked fish for two main reasons. Now, here the FDA was not only regulating hot smoked fish, it was regulating many other kinds of fish. However, in regards to hot smoked fish, these issues arose, right, that were brought to the court. And so the court declared the regulation procedurally invalid as it applied to hot smoked fish for two main reasons. The FDA did not share the scientific data underpinning the regulation with the interested parties. This prevented meaningful comment because parties could not critique the basis of the rules, right, the regulations. The agency also failed to respond to vital and material objections. Specifically, it ignored Nova Scotia's warning that the heat would destroy the product and failed to explain why it rejected a species by species approach, right? Because there were many species that were being considered or were being formed part of these regulations, right? So it was procedurally unfair for these two reasons, right? The court held then that while public health can't override commercial concerns, right? That means that public health can override commercial concerns because that's the mandate of the FDA and these regulations, the administrative record must show that the agency actually considered the commercial feasibility and provided a reasoned explanation for its decision. Therefore, the agency's silence on these vital questions, the first question, right, in terms of the process and the commercial feasibility, right, and the scientific data, and this process, alternative processes and feasibility. Its silence on this rendered the rulemaking process arbitrary, right? They were considered arbitrary. In other words, they were rendered invalid, right? And then now we look at the next case, United States case, which is the case of Chocolate Manufacturers Association versus Block. Okay, the facts of this case: Chocolate Manufacturers Association challenged a final rule issued by the USDA, the United States Drug and United States Department of Agriculture, rather, right? The dispute involved federally funded WIC program, which is a special supplemental food program for women, infants, and children, which had permitted flavored milk, chocolate milk, right, since 1973. In 1979, the USDA, United States Department of Agriculture, proposed a rule to revise the WIC food packages to better manage fat, sugar, and salt content, right? The proposed rule and its 12-page preamble explicitly permitted flavored milk and did not mention concerns about its sugar content, although it discussed sugar at length in relation to juices and cereals. However, after receiving 78 comments, mostly from WIC administrators, right, suggesting its removal, the USDA's final rule banned flavored milk entirely. Now, let's look at what were some of the issues in regards to this particular decision by the USDA in terms of these regulations, right? Right. So the court had to decide whether the USDA provided adequate notice under what they call in America, right? For them, it's the Administrative Procedure Act, right? Specifically, did the original notice sufficiently alert interested parties that flavored milk might be eliminated, thereby giving Chocolate Manufacturers Association a fair opportunity to comment, right? Looking at its procedural fairness, right, in terms of how this rule came about to eliminate chocolate milk. And you must note that Chocolate Manufacturers Association are a group of companies that then also benefited or supplied the USDA with flavored chocolate milk. And so the elimination of this chocolate milk then would affect their interest, right? However, noting from the facts, there was no indication that it would be banned, but later on it was, right? And so the court is then now looking in terms of one of the issues it must decide is whether that process was fair, right? Whether that procedure was fair. The court adopted, this is very important, the logical outgrowth test to measure the adequacy of the notice, right? The test states that a final rule is valid only if the changes from the original proposal are in character with the original scheme and are a logical outgrowth of the notice and comments provided. A notice is sufficient if the final rule materially alters. A notice is insufficient if the final rule materially alters the issues involved or substantially departs from the original terms. In other words, it is not a logical outgrowth, right? you will remember, or you'd be advised that when a particular issue is brought in for comments, or a particular rule is brought in for comments, it will naturally limit those comments to the subject of that rule. And so if the subject was never flavored milk, but rather sugar in cereals and juices, the elimination of chocolate milk then would not be a logical outgrowth of that, right? Okay, so let's look more on what the court found. The court found that the USDA's notice was inadequate for several reasons. However, please do then take notice of this logical outgrowth test, right? It's a very important test, right? To measure the adequacy of a notice. So the court's findings were that the USDA's notice was inadequate for several reasons. The first being that the detailed discussion on sugar in other foods, cereals, and juices, the first reasons was that there was a detailed discussion on sugar in other foods, while there was silence on milk, and this led parties to believe that flavor milk was not under consideration for removal. And so it was misleading, right? The final rule, the court found, was not a logical outgrowth of that notice, right? It was the direct opposite of the proposed rule, okay? There was no prior history or indication that flavored milk was being scrutinized for removal, and also that the final rule was based on comments from 78 opponents, mainly administrators, while CMA and other proponents who were chocolate milk providers were denied the chance to respond. They were not allowed to respond. They did not get an opportunity to respond, undermining the integrity of the process. So it was not only that it was not a logical outgrowth, but for these various reasons, right? And so the court reversed the decision of the lower court and ordered the USDA to reopen the comment period, allowing all interested parties a fair opportunity to address the proposed elimination of flavored milk. Okay, so that's how the court dealt with the issue that was brought about by this particular litigation. Okay, and so that's the last case in this lecture. I hope that this lecture, like all lectures, was helpful, and it is goodbye from me. All the best.